Yet more it came from the comments. People have asked, now that Harry has issued a notice of discontinuance, could he actually reissue a fresh claim? Well, the answer for this one is no. But let me explain how discontinuance works and how you can, in some circumstances, actually issue a fresh claim. And then you can see why it doesn't apply in this case. So when you file a notice of discontinuance, you agree that you are abandoning the whole or part of the claim. I mean, sometimes you can carry on, with the bits that you think you got a punt on, but you realise that I've got no chance on this bit, I'll just get rid of it. Or you can just say, I just throw the towel in altogether. And the consequences of that are that you agree to pay the other side's costs up to the date of the notice of discontinuance. It gets a bit more complex when you discontinue part of a claim, because then you have an assessment as to, how you allocate the funds so far. But let's say you've done that, but then you actually want to reissue either a whole fresh claim if you've discontinued the whole of the claim, or you want to reinstate the bits you abandoned. Can you do that? Yes, but only with the permission of the court, which is rarely granted. Because in litigation there is this idea that finality and certainty is desirable, that people shouldn't have things hanging over them. That's why we have limitation periods. However, if you have discontinued, you can say, I want to reissue, and then you say to a judge, this is why. Now, the test for whether you can reissue, the court themselves say it is, quote, less than clear. That's very helpful, isn't it? But here are some factors where they have allowed, to go against the starting point, which is, no, you can't reissue. They've done it where the other side have deceived or misled somebody, for instance. We've got this evidence, or we've got this witness, and they're going to say that, and it turns out they don't have. Sort of misconduct on their part that overestimates their position and forces you to take a pragmatic view. When fresh evidence has come to light that actually bolsters a claim, so you issue your claim, you go, you know what, we're in the right, but we can't prove it, so we may as well discontinue. But then actually you do find some evidence that assists you. Then you can go to the court and say, look, that's why the situation has changed. Also, if there's been an appeal court decision that's changed the law and suddenly the law is in your favour, you took a view because you went, well, the law's against us on this, but then there's an appeal decision, and you go, oh, actually now the law's in our favour, can we do it? So yeah, if you want to, they may allow in those particular circumstances, and it'll either be allowing you to issue a fresh claim, or if you'd abandoned part of the claim, to re-amend your particulars of claim to add back in. This is all to do with those things arising out of the same facts. Obviously, if you've got a completely separate claim, then you can bring that. However, we have something called the rule in Henderson and Henderson. And what that says is, all claims that could properly be brought together should be brought together and issued at the same time. So, you're not willy-nilly just piecemeal dropping claims in against people. They have to be related. So say, for instance, you had a dispute with a builder about your kitchen extension, and then a few weeks later he accidentally ran you over. It wasn't connected to, it wasn't connected to the dispute. Then, yeah, you could issue a separate contract claim and a separate personal injury claim for the accident. That would be fine. But if you had, say, a series of rows with the builder, and there were lots of, disputes about, inadequate work, you'd have to plead all of those at the same time. You couldn't say, well, I'm going to sue him first with all the stuff about the kitchen, and then I'll look about my patio extension later. And that applies when they're considering whether, you do actually to grant permission. Because sometimes people will try and sneak additional claims back in and say, oh, well, we abandoned this when I want to put it in. And the court will say, well, actually, you should have issued that at the same time because of the Henderson the Henderson rule. So yeah, I mean, that's pretty much it. Generally speaking, like I say, once you've issued a notice of discontinuance, the court is very much, no, sorry, that's the end of it. But with the court's permission, which is rarely granted, you can issue a claim. But in this particular case, You can only reissue the claim if you're still within the limitation. The limitation period for defamation is only 12 months, so Harry is well past the time to reissue a claim now. And the mere fact that the newspaper might repeat the allegations, it used to be that every time you repeated the allegation, time started running again and it created a fresh limitation period. That has changed now, so you have to sue from the first time that the defendant made the statement. If somebody else was to make the allegation and you argued it was defamatory, then yes, you could issue a claim there, because that's the first time they said it. We do get into this thing though, like say called issue estoppel, or res judicata, where the argument is, well, this has already been dealt with in one court case, so it shouldn't be, your chance to run it again. We've had a defamation claim that you've either lost or discontinued, and now you're suing somebody else over the same facts. Well, if you lost that case, that means you should lose this. But res judicata only applies when it's between the same parties. I mean, that all cropped up in that other case, with the actor and the actress, where they actually tried to run a res judicata thing on the back of the English proceedings, but they said there, no, although it was the same claimant, it was a different defendant, so res judicata doesn't apply. So there you go. As always, hope you found this vaguely useful, vaguely interesting. If you did, please consider liking, sharing and subscribing. Regular viewers will know this is one of my favourite spots. This is a place called Kennel Vale, which is an old gunpowder works, and I'm in one of the old grinding houses. They're all driven by big water wheels, so there's a big sluice up behind me. But it's in a valley, and it was all designed, they modified the river, not just to drive the mills, but also it's designed to throw as much spray up as possible, because then that kept the gunpowder damp and there was less risk of explosion. And you've probably noticed these walls are really, really thick, but they just put effectively almost thatch roofs on the top. So if there was an explosion, the explosion went all the way upwards. There were a few explosions here, and I won't be going into gory details. It's amazing how far people can fly when they're propelled by several tons of gunpowder.